All right, hello everybody, and welcome again to the University of New Mexico Law and Mental Health Didactic Series hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. We're thankful to have all of you in attendance for today. I'm Dr. Anthony Perillo. I am the Forensic Psychology Training Director here in the Department of Psychiatry and Behavioral Sciences at University of New Mexico. As a heads up for our talk today, please ask questions in the Q&A box, not the chat box, the Q&A box, anytime you feel comfortable. We will reserve questions until the end. We'll try to do as many as we can. Just forgive us if we can't get to yours. For those of you who want continuing education credits, you do have to stay for the full hour, but you don't have to stay longer than that. We'll let you know when the hour is passed, and there will be info in the chat box. For those that are pursuing continuing medical education credits, there will be a sign-in in the chat box coming in shortly. And the link for the APA continuing education credits will come around the last 5 minutes. Open that link and make sure you save your certificate before the talk closes. We have no way of saving copies for you or accessing the link for you later on. A recording of this and the PowerPoint slides will be available for all of you in about a week. At that time, for next week's talk, we have Dr. Camilla London Newton presenting on reliability, credibility, and competence of children's forensic testimony. But we're here today to talk with Chris Slobogin. We're thrilled to have him here. Christopher Slobogin occupies the Milton Underwood Chair at Vanderbilt University Law School. He's co-author of Psychological Evaluations for the Court for the Guilford Press, Minding Justice from Harvard University Press, and Proving the Unprovable from Oxford University Press. He also has scores of articles on a number of issues related to mental health law. Chris, on behalf of the University of New Mexico, we're really excited to have you join the series and thankful that you'll be sharing your expertise with us today. I will now throw it over to you.
Okay, well, thanks, Anthony. And welcome, everybody. I'm looking forward to this. I have an addendum to the introduction that Anthony gave you. I also have written a book called Just Algorithms, Using Science to Reduce Incarceration and Inform a Jurisprudence of Risk. I'll reference that book again, but a lot of what I'm talking about today comes from that book, which just came out last year. The other addendum I have to the introduction is I want to stress that I am a law professor. It says here, affiliate professor of psychiatry. That's a little misleading. I'm not a psychiatrist. I have a secondary appointment in the psychiatry department here. I like to pretend like I'm a doctor, and I throw around a lot of diagnostic terminology, but I am not a psychiatrist or a psychologist. I'm a law professor, pure and simple. So most of this is going to be from the perspective of a lawyer, from the perspective of the legal system. I will, of course, talk a little bit about risk assessment from an empirical perspective, but as you can tell from the title, this is all about what the law should be doing. Unfortunately, it doesn't do most of what I think it should be doing. You all are very familiar with the insanity defense and probably with the terms actus reus and mens rea. And if you don't know those terms, you of course know about the conduct and mental state requirements of crimes. There have been thousands and thousands of pages written about that kind of stuff. The insanity defense, other kinds of defenses, the elements of crime. There's been virtually nothing written about what I call jurisprudence of risk. There's a huge jurisprudence of culpability, but not much written at all about a jurisprudence of risk. And I think that's an application. I think the law has failed miserably, especially since the law continues to ask people like you for assessments of risk in all sorts of contexts. At sentencing, pretrial detention, parole decision-making settings, and civil commitment, sexually violent predator laws. Those are all situations where risk might be an issue. The law wants answers about risk or about dangerousness, but it does a very poor job telling developers of instruments, in particular risk assessment instruments, and telling clinicians who are doing risk assessments exactly what they want. So what I'm going to be talking about today is, at least the phrase I use, is a jurisprudence of risk, the kinds of things the law should be providing people who do risk assessment. the criteria that the law should be providing people who do risk assessments. So I want to start off with just examples of 3 risk assessment instruments. You all know about these. I'm not telling you anything new, but I think it's useful to talk about them briefly so I can use them as examples later on. So here's the Violence Risk Appraisal Guide. Probably most of you are familiar with this. It's got 12 risk factors ranging from diagnoses with respect to psychopathy and other DSM diagnoses to, and DSM diagnoses to various static factors like age, family life, and then various factors having to do with antisocial behavior. And each of those risk factors is associated with a given weight or a different score. Those scores are supposed to be added up, and then a person is associated with one of 9 different bins. So for instance, if the score is 0 to 6, that person is associated with a group that has a 35% probability of or 35% of whom recidivate within a 7-year period. If the score is 21 to 27, that person's in a group 75% of whom recidivate within 7 years. And there are 7 other bins. At least this is the version of VRAG that I'm familiar with. There might be revised versions, but it really doesn't matter. I'm not really trying to give you a lesson on the VRAG. I'm just trying to use this as an example of one kind of risk assessment instrument. Here's another example called the compass. You may have heard of this one. It's certainly been in the news a lot lately. To the extent you read any news about risk assessment instruments, you will have heard of compass. And this has made the popular press too, not just the professional press. So you can see here, the compass looks at 5 different areas, 5 different domains is what they're called. And they're pretty obvious domains. If you do risk assessment, they make sense: criminal involvement, relationships, personality, attitudes, etc. Unlike the VRAG, it's not entirely clear what the risk factors are or the weights that are given to the risk factors. The VRAG is very transparent in that regard. You know exactly what the 12 risk factors are, what the weights are. Here, there are over 120 questions you can ask in connection with the compass, but it's not clear which of those questions are relevant to the ultimate conclusion about risk. And the reason we don't know that is Compass is developed by a private company called Equivant, and they're claiming trade secret protection. So we don't know what is behind the compass. But what happens is, after the evaluation is done, the algorithm is applied, you are supposed to be able to assign someone to one of 10 deciles on either violence recidivism risk, general recidivism risk, or pretrial risk. Now, what the decile means is that the individual is categorized depending upon the risk levels of the sample. So if you're in the 10th decile, that does not mean that you're associated with a group 90 to 100% of whom recidivate. It means that you are in the highest risk group, at least you're associated with the group that was considered the highest risk in the validation sample. So that's important to understand. A lot of judges don't understand that. They think, hey, 10th percentile, 9% chance of recidivating. That's not what that means. And then the final risk assessment instrument I want to briefly describe by way of illustration, something I'm sure all of you know about, the HCR20, 20 risk factors, historical, clinical, and those associated with risk management. You see what they are here. The historical factors are static, clinical factors and risk management factors are not necessarily static. And I raise that because unlike the VRAG, where all the risk factors are static, many of the risk factors here are what you all call, what professionals call dynamic factors, which are changeable factors. So it's different than the VRAG, and it's different than the compass in the sense that we know exactly what the risk factors are, but it's different from both the VRAG and the compass because it doesn't try to come up with definitive conclusions about probability of recidivism. Rather, the developers of the HCR20 strongly suggest that at most the clinician conclude the person's high, medium, or low risk, and even that arguably should be avoided. And instead, what the evaluator should do is tell the decision maker, whether it's the judge or parole board or what have you, that this person has some factors that might lead to risky, bad, antisocial behavior unless they are dealt with through risk management, through treatment. So it's designed to try to get people to identify what might be problematic areas and then let the decision maker know about those. However, because there has been an attempt to show the ACR 20 is just as good as straight actuarial instruments like the VRAG, there have been attempts to validate the instrument through assessing its accuracy. And so what you could do with the ACR 20, it's not recommended, but what you could do with the ACR 20 is assign scores of 0 to 2 with respect to each of the 20 factors, which would mean the highest possible score would be a 40, the lowest possible score is 0. And doing that kind of thing, some researchers have found that, at least with the validation sample they used, that a score of 1 to 14 is associated with 11% chance of recidivating. Score of over 35 person might be in a group, 75% of whom recidivate within a follow-up period of 2 years. So those are some risk assessment instruments. As I said, I'm just using those as illustrations. I'm not endorsing any of them. I'm just describing them as the kinds of instruments that have been used. The VRAG and the ACR 20 and the COMPASS are all used fairly routinely. VRAG more in Canada, but the VRAG is also used in the United States. ACR 20 and the COMPASS are used quite often here in the United States. So what do I want to say about these kinds of instruments? Well, this is where the book I mentioned earlier comes in. Actually, I noticed already I have a typo here. It's not 2020, it's 2021 when the book came out. And what the book talked about are 3 general principles that risk assessment instruments, developers of risk assessments, and by the way, also people who do risk assessment without instruments, all 3 of those situations ought to follow 3 principles that I describe in the book. And I call them the fit, validity, and fairness principles. They could be called other things, but I decided to come up with these 3 words: fit, validity, and fairness. So what's the fit principle? It basically is the idea that the law needs to give developers and people who do risk assessment the criteria that define risk. The law needs to define, as it says here, the legally relevant components of risk so that developers and users know what to focus on. As I'll talk about, the law has done a very poor job at this, especially as compared to the job it's done with respect to defining culpability, actus reus, mens rea, the various defenses, and so on. So that's one principle. Second principle, the validity principle. And this, of course, is something you're familiar with, that risk assessment and risk assessment instruments ought to be able to do what they purport to do. At least we ought to have some fairly good evidence of validity before we use any particular risk assessment technology. And then finally, there's the fairness idea. And fairness obviously is a very broad concept, and it could incorporate the fit and validity stuff. But what I mean by fairness is something else. The law needs to be very clear about what kinds of risk factors risk assessors may use. And as we'll talk about, you may already be aware of this, but you may not be. We'll talk about some risk factors may be impermissible to use for constitutional reasons or for policy reasons. And so it's very important to think about the fairness issue as well. There are also fairness issues having to do with the process by which risk assessment is conducted. And that, I think, fits under the fairness criterion fairness principle better than either the fit or validity principles. So those are the 3 principles: fit, validity, and fairness. I want to go through each of them to tell you what I think the law should be doing. And I guess I should make this caveat. This is what I think the law should be doing. It doesn't mean the courts think they should be doing this. In fact, it seems pretty clear the courts haven't given much thought to this at all. But when I talk to judges, I make the same points. And I think, generally speaking, the judges agree. They are lawyers, so they do believe that in general, the law should provide criteria for whatever the issue is. And so they agree with the idea that the law should be better defining what it means by risk, and it should be coming up with a more complete and explicit jurisprudence of risk. So let's start with fit. And again, that has to do with defining the criteria for risk. And as I've already said, this means the legislatures or courts, and obviously you could have both entities at work doing this kind of thing. I happen to think legislatures should take the first stab at it, with courts then filling in the gaps. In any event, the legal entity ought to define what it means by risk or by dangerousness. And of course, those words are interchangeable in the law. I think mental professionals, psychologists and psychiatrists tend to like to use the word risk. Lawyers often use the word dangerousness. But for present purposes, I'm talking about the same thing. Unfortunately, the law's not done a very good job here. For instance, I'm just going to give you some examples. The Bail Reform Act passed by Congress back in the 1980s. It does authorize pretrial detention based on risk. How does it define risk? It tells the judge to look at the seriousness of the danger to any person. Doesn't define danger. Doesn't make any other effort to define seriousness. Just says the danger has to be serious. Danger to other person has to be serious. That's it. That's the entire definition of risk under the Bail Reform Act. And by the way, this act is replicated or duplicated in a number of states. Even though it's a federal law, those states that allow pretrial detention based on risk use similar kind of language. This is even worse, in my opinion. In Texas, we're talking about the statute that authorizes execution if the prosecution can show that someone convicted of capital murder it poses a probability of criminal acts of violence. That's it. There's no further definition. Now, I suppose you could argue, if you're a lawyer like I am, that probability means what, 51% likelihood of committing a criminal act of violence. That would certainly be a plausible interpretation of this. But the Texas Court of Criminal Appeals, which is the court that deals with criminal cases, the ultimate decision maker in criminal cases in the state of Texas, has refused to define the word probability. And it's even said, hey, it could be as low as 1%, but we're not going to really tell you what it is. We're going to leave it up to the jury. So it specifically rejected the argument that probability be defined as more likely than not, or 51%. So once again, we got a fairly vague, ambiguous definition of dangerousness, and that's even in the death penalty context. Then you look at your typical non-capital sentencing statute, and it uses a phrase like this: if the person poses a risk of reoffending or is a threat to public safety, you can enhance the sentence. Well, I'll be blunt about it. I think that's ridiculous. You would never get away with this kind of definition if we're talking about culpability at a criminal trial. But at sentencing, we're talking about risk, no problem. You can use this kind of very vague, ambiguous language. So this is a fit problem that I'm talking about. Ideally, I think, and this is what I argue in my book, the courts ought to be, and the legislatures ought to come up with legal criteria defining risk or dangerousness in terms of probability that is required, the outcome being predicted, that is violent acts, any acts, threats to persons, threats to property, so on and so forth, the time frame of the prediction, that is, what is the follow-up period, and the extent to which alternatives to detention will be considered. So in other words, even if a person's high risk of committing a violent crime, as we all know, detention might not be the best way to manage that risk. There may be alternatives. So I think all four of these variables ought to be relevant in risk assessment, and legislatures and courts need to give us a better clue as to what risk means in connection with all four of these variables. Those variables might differ depending upon the context. In other words, probability, outcome, time frame, and alternatives might be different in the pretrial context as opposed to the capital sentencing context or the non-capital sentencing context. So I'm going to say a bit more about all four of these variables. And by the way, I'm going to spend more time on the fit principle than on the validity and fairness principles, because I think the law has fallen down. It's done the worst job of dealing with the fit issue of any of these three, but it's done a bad job on all three. But I think it's done the worst job in terms of the fit principle. So what should the fit principle be? The law should identify what X means in the following sentence. The person should be associated with a group X% of whom will reoffend. Now, I know this is hard to do. As developers, if you're a developer of risk assessment instrument, I'm sure you're saying, well, there's no way we can do that with any degree of precise accuracy. I'm going to get back to that issue in a second. Right now, I'm just talking about the criteria. And what I want to talk about is how the instruments that I described to you earlier do an okay job or not an okay job in connection with this particular aspect of the probability variable. So the VRAG does give us a percentage that can be associated with an individual. And then you can say this individual's within a group, 35% of whom or 60% of whom recidivated within a certain period of time. So the VRAG does meet this criteria. The HCR20, not so much, because as I said before, if used the way it's supposed to be used, the HCR20 doesn't really give us any probability information. You might get a statement about whether a person's high, medium, or low risk, but we don't know what that means. The HCR20 developers don't really want clinicians defining that, and in fact, really would rather not have the assessors even use those phrases, but rather instead just talk about the most prominent risk factors in a given case. Well, that might be very good for risk management purposes, but if we're trying to figure out whether at the front end we enhance a sentence by 5 years, whether we release someone on parole, whether we detain someone pre-trial, it's not as helpful as it could be, and the law needs to tell us what kinds of probabilities it's associating with high risk, medium risk, or low risk. The VRAG is also preferable to the COMPAS because, as I said before, all the COMPAS gives us is the decile without telling us what probability of recidivism is associated with the given decile. So if the 10th decile means that a person falls within a group, 30% of whom recidivated within a 5-year period, that's what the law needs to know. Telling a judge that a person's in the 10th decile is almost useless. I mean, it does mean the person's higher risk than someone who's in the 9th decile, but it doesn't give the judge the most pertinent information because, and this is my assertion, if the 10th decile means only that a person's in a group, 30% of whom will recidivate, if I'm the judge, granted, I'd be different than other judges perhaps, I wouldn't enhance a sentence. I'd release a person on parole. 30% is nothing. To me, if it was 70%, yes. If it's 30%, not a big deal. Obviously, there's a normative judgment being made here about whether X, in terms of allowing a sentence to be enhanced or a person to be released on parole, whether X should be 30, 70, 10, or 80. That's the law's job. That's not the developer's job. You need, though, to tell the law what X means. If you can tell the law that, then the judge makes a decision about whether that's sufficiently risky enough to take this particular legal action. That's why the judge gets paid big bucks. They're the ones that have to make that tough normative decision. You get paid your bucks by telling the judge or the parole board what X is. And again, the HCR20 and COMPAS don't do a great job of that. The VRAG, I think, does do a pretty good job of that. So what should X be? Well, it depends upon the context. So pretrial release, excuse me, not pretrial release, prison release. That is release by a parole board, let's say after a person serves a certain amount of his sentence, or diverting a person from the prison system entirely. Maybe, and this is just a suggestion, it's the suggestion I made just a second ago, if X is 30 or higher, maybe some kind of deprivation of liberty should occur. But if it's lower than 30, maybe it shouldn't. And that's my normative judgment. A different judge's judgment might be different. Where do I come up with 30%? Well, it turns out, according to Bureau of Justice Statistics, about 30% of those who are released from federal prison commit a violent crime. And to me, that's an interesting and useful benchmark, and it might be my benchmark if I were the decision maker. Again, though, that's up to the judge, the parole board, the legal decision maker. What the developer of the instrument, what the risk assessor is doing is providing what X is. And obviously, as I just suggested with the example I gave, the probability interacts with the second variable, the outcome variable. 30% of committing a violent crime, I might reach one conclusion. If it's 30% probability of committing any crime, I might reach a different conclusion. I'm more likely to enhance a sentence in the first situation than the second. So again, X is important. It's going to vary with respect to the context. So this is what you might get with the VRAG. This is actually a chart of what one study of the VRAG found. These are the 9 bins I referred to earlier. So you notice the recidivism rate of people who fall in bin 9 is quite high. The recidivism of people who fall in bin 1 is quite low. That's pretty good calibration validity. I'll talk more about calibration in a little while. I will hasten to add, those of you who do this kind of stuff know it's very difficult to come up with these nice looking charts that look like they go from the lowest to the highest, from bin 1 to 9, with any degree of confidence. I'm going to come back to that. But let's assume we've got pretty valid results that show what I'm showing here on the chart. You'll notice that if you look down here at the bottom, see if I can get my cursor over here. Yeah, you'll notice that if we take as our cutoff a 30 to 35% probability, that is, the person's associated or within a group, 30 to 35% of whom recidivated within the follow-up period. If that's our cutoff, 75% of the sample would be below the cutoff. Only 25% of the sample would be above the cutoff. Why? Because if you look at the percentage of the sample, this only adds up to 25%, as indicated by the parenthetical here, 12 plus 7 plus 3 plus 2 plus 1. That's 25%, I think. And this adds up to 75%. So if that were the cutoff, what the judge would be saying is, well, only people who are in bins 5 through 9 would be considered high enough risk to justify a deprivation of liberty. Everyone else would not be considered high enough risk to justify a deprivation of liberty. That's the way it might play out in my legal world. And without this information, the judge can't do that. The judge just has to make a decision based on a clinician saying, oh, the person's high risk, person's medium risk, person's in the 7th decile. Well, what the hell does that mean? Judge has no idea. That's why I think this kind of information is useful. So that's the prison release situation. What about pretrial detention? Risk assessments also use pretrial. Well, arguably here, this is a normative judgment again. Arguably here, X should be a lot higher. Why? Because the person hasn't been convicted yet, right? In the previous situation, we're talking about prison release and diversion. Up here, person's been convicted. Arguably, the state has more authority to deprive people of liberty there. Here, we're talking about a person who has been arrested but not convicted. So arguably, again, X should be higher. And in fact, research by Nick Skurich and Krauss indicate that even lay people are willing to have X be as high as 60% in the pretrial detention situation. So we might have a different X depending upon the context. What about this situation? This is a different scenario than maybe you're associated with or familiar with. The state of Virginia decided to go from indeterminate sentencing to determinate sentencing. Meaning what? That judges would have very little discretion as to the sentence that would be assigned an individual, and there no longer be any parole board which could act as a safety valve to release people at the back end of their sentence. So the Virginia legislature was smart. It knew that, hey, if we go to determinate sentencing, we're going to have a lot more people in prison. That's certainly been the experience of jurisdictions that go to determinate sentencing. Judges have less discretion, parole boards have no discretion. So more and more people are going to prison and staying there. So what did the Virginia legislature decide to do with this? Well, they said, okay, we're going to have more people in prison. We got to have a safety valve. We've gotten rid of the parole board, so that's no longer a safety valve. What we'll do is we'll tell the Department of Corrections to come up with a risk assessment instrument that will be designed to make sure that we can reduce our prison population by 25%. So in other words, low risk or the risk that allows release, low, medium risk, whatever you want to call it, the risk that is not sufficient risk to require continued detention would be whatever it takes to reduce prison population by 25%. That was a directive from the Virginia legislature. And that's what the Department of Corrections came up with. They came up with a series of risk assessment instruments that allowed the Department of Corrections to reduce the prison population by 25%. Most of these were what we would call nonviolent offenders, people committed low-level offenses, misdemeanors, low-level felonies, felonies like fraud. And that's another use of the risk assessment instrument. So what would X be in this kind of setting? Whatever achieves the reduction of 25%. So the bottom line is X is a very important thing to figure out, and the law has done nothing along those lines. The Texas Criminal Court of Appeals, a reprehensible job. So it can be anything. We're not going to assign percentages. Just go out there and you figure it out for yourself, juries and judges. We're not going to give you any direction whatsoever. Some courts will say, oh, it has to be a probability, which is more than a possibility, but that's all they say. Okay. I think it would be much better if courts gave us some kind of quantification. And another thing that ought to be considered is whether, even if we set X, let's say at 30% initially, let's say at a parole board decision-making setting, after a person serves minimum part of his sentence, we got a parole board decision. X at that initial parole board decision would be 30%. Perhaps as time went on, X would have to be higher. Now, why would that be? Maybe at the second parole board hearing, it would have to be 40%. Why would it have to be higher? Well, if you think about it, when we're talking about culpability, backward-looking assessments of culpability, if we want to give a person a long deprivation of liberty, have a long sentence based on culpability, the person has to be particularly culpable, and that's called proportionality, right? That's the word that's given to that idea, that sentences should be proportionate to a person's just desert, to a person's culpability, to a person's blameworthiness. Well, I think there ought to be an analogous concept called risk proportionality. If we're basing a deprivation of liberty on risk as opposed to culpability, then the longer we keep someone in based on risk, the more risk that ought to be shown. And I would base that on the Eighth Amendment, which is the amendment that talks about cruel and unusual punishment, and is the amendment upon which the proportionality reasoning is based. So that's getting maybe a little bit technical, but I think it's something that ought to be considered by the law, and the law ought to make it clear whether it's going to adopt this kind of approach. That is, the longer you keep someone detained, the more risk, based on risk, the more risk you have to show. So that's the probability variable. What about the outcome variable? As I said, the probability variable and the outcome variable are very closely related. My normative preference is that detention based on risk should only be permitted if it's a risk of violent crime. That's contestable. Some people would disagree with that. But this, again, is something the law has to decide, and the law has not decided. The law very rarely has given us a definition of the outcome variable. Now, there's some exception to this, which I'll get into in a second. But most of the time, remember the Bail Reform Act? Serious danger to any person. What does that mean? It doesn't even reference violent crime. And I think one reason I'm confident that this is a normative judgment that would not be dismissed out of hand is because the Supreme Court itself has suggested in the Fushi cases and Salerno cases. I won't go into those in detail unless you want me to later. But those two Supreme Court decisions suggest that if you're going to confine someone based on a risk assessment, it's got to be a prediction, an assessment of risk that the person will commit a violent crime, not just a misdemeanor or a low-level felony that does not involve violence to a person. Okay, so there's some legal precedent for that idea. And it suggests, for instance, that if you're yanking someone back into prison because they've committed a technical violation on the grounds that, hey, now they're higher risk because they've committed a technical parole violation or technical probation violation, that would be impermissible. Because usually a technical violation does not suggest in any way, shape, or form the person poses a risk of violent crime. Maybe they've committed a technical violation, but that doesn't mean they should go back into prison. Maybe conditions of release should be refined. Maybe there should be more supervision of that person, but that doesn't mean the person should be put back in prison. Unfortunately, in California, about 30% of the people in prison are there because of technical violations. If that's based on risk, it's totally impermissible under the guidelines that I'm talking about now. So the point I'm trying to make is, obviously the normative judgments can be different depending on the legislature of the court. But once you make that judgment, it can have real bite. It can have a huge practical impact on who is in prison, who is detained prior to trial, and who is not. And the other point I want to make, which is directly relevant to those of you who develop instruments or use instruments, is that interestingly enough, the VRAG and the ACR 20 may fall down on this particular variable if the outcome variable is defined as violent crime. Why do I say that? According to my reading of the VRAG literature and my reading of the ACR 20 literature, their outcome variable was a simple assault. Okay? So in other words, a person was considered to be a relevant recidivator if they committed a homicide, armed robbery, etc., but also and only if they committed a simple assault. Well, in my opinion, again, it's just my opinion, my normative opinion, you should not be able to add any time to a person's sentence or deny release on parole simply because you think they might commit a simple assault within the next year or two. That should not be sufficient grounds for depriving someone of liberty. So if you buy my normative judgment, the VRAG and the ACR 20 are irrelevant. They do not fit the legal question until they're tested using an outcome measure using a real violent crime, not a punch to the face, but an aggravated assault or something at least more serious than a punch to the face, which is all a simple assault is. Then they're just simply not relevant. The research upon which they're based does not address what I would consider to be the relevant legal question. That is a huge point. Okay, that could make a significant difference on how instruments are developed and which ones should be used by the courts. Of course, you have to accept my normative premise that violent crime means something more simple than a punch, more serious than a punch in the nose. So what should violent crime mean? Again, the courts have not done a very good job. Remember what the Texas death penalty statute said, criminal acts of violence. That's what the death penalty statute says, criminal acts of violence. What is that? Is it a punch in the nose? Well, if it's a punch in the nose, then the VRAG and the ECR 20 are fine. You can use them in a death penalty proceeding. Under my definition, you could not, but under the Texas definition, maybe you can. And in fact, the Supreme Court of the United States said in Jurek versus Texas that despite the ambiguity of this phrase, it was not unconstitutionally vague. Okay, that was the argument in Jurek made by the defendant. This language is unconstitutionally vague. You should not be able to kill me based on this kind of language. The Supreme Court said, yeah, we can kill you. It's not unconstitutionally vague. However, and this is an important however, 4 decades later, Supreme Court seemed to reverse course. In the Armed Career Criminal Act, ACCA stands for Armed Career Criminal Act, the definition of violent felony for when you could enhance a sentence based on a violent felony was burglary, arson, extortion, or other conduct that presents a serious potential risk of physical injury to another. That language, the italicized language, is actually more specific than what the court dealt with in Jurek. And yet, in Johnson, the court said that italicized language was unconstitutionally vague. It struck down the statute. That's a big change from Jurek. Why did the court strike it down? Because it said, hey, this language could include witness tampering. It could include failing to stop a car when the cop tells you to stop, because it's a potential risk of physical injury. It could involve an attempted burglary. The court, by implication, was saying witness tampering, failing to stop a car, and attempted burglary should not be considered violent crimes. And yet this language would include all of that within the definition of violent crime. So you see what I'm getting at. The courts need to do a lot better job, and the legislatures need to do a lot better job of defining the outcome variable. If it's violent crime, apparently these 3 things right here are not violent crime, and you can't use them when you're developing a risk assessment instrument as an outcome variable. You got to use something more serious. I would argue more serious than a punch to the face. So in the death penalty context, what should be the outcome variable? Well, I would argue not just an arrest for a violent offense, along the lines of what we've been talking about, but a conviction for a violent offense. Because, this is something you may know, but I think it's worth emphasizing, up to 50% of all arrests result in dismissal of charges. An arrest does not mean the person did it. Now, they might have done it, in which case, hopefully they're convicted. But sometimes they didn't do it at all, and other times they did something, but it wasn't the crime for which they're arrested. It was a lesser crime. So that would lead to the argument that the outcome variable has to be a conviction for a violent offense, not just an arrest for a violent offense. Unfortunately, a lot of RAIs, a lot of risk assessment instruments use arrest as the outcome variable, not conviction. Same thing with non-capital sentencing. If you're using a risk assessment instrument in non-capital sentencing, it should be conviction of a violent crime. If a person, that is, you have to predict the person would be convicted of violent crime if they were released by a parole board or not sentenced to prison at the front end. What about pretrial detention? Now here it might be different. I've been talking about convictions for the death penalty and non-capital sentencing. Maybe when we're talking pretrial detention, the outcome variable does not have to be conviction for a violent crime, but only arrest for a violent crime, because that's all that's likely to happen. within the short period of time between arrest and the time person must appear for trial. That's what the pretrial detention decision is all about, of course, is will the person commit an offense within the short period of time between arrest and the time of trial. The other outcome variable that is relevant in pretrial detention is failure to appear, right? And I have here CFPSA, which is the public safety assessment instrument that the Arnold Foundation has developed. And correctly, the PSA has two different outcome variables. One is risk of committing a violent crime, and the other is a risk of failing to appear. So the outcome variable is going to be different depending upon what the court are interested in. So then the final context that I want to mention, some context that maybe some of you have had to deal with, is detention as a sexually violent predator, which can happen after a person's completed their sentence, or maybe even in lieu of a criminal prosecution. And here again, I would say the outcome variable should be conviction for a violent sex offense, not a conviction for lewd and lascivious behavior or one of those kinds of relatively minor sexual offenses, but a more serious offense. Now, again, if you're a developer of an instrument or use these instruments, you might be saying, well, if those are the outcome variables, the only outcome variables that are relevant, it's going to make it much harder to come up with the sample that gives us meaningful data. Well, that may be the case, but the law should know that. If, as I'm suggesting, the outcome variable should be conviction for a violent offense, and that occurs at such a low base rate that it's hard to get any meaningful data that would allow us to predict or come up with a meaningful group that will meet that outcome variable, that's the way it goes. That is a message the court should know. And it may be that there'll be very few people who will be deprived of liberty based on an assessment of risk, which may be the right normative outcome. So those are the probability and outcome variables. What about the duration variable? I'm going to be finishing up here in about 15 minutes, believe it or not. I can go more quickly through the rest of this. Duration variable. So there should be an assessment not only of whether this person has a probability of committing a certain kind of any social act, we should also know during what period of time. So death penalty, presumably that period of time can be indefinite. We're trying to figure out whether the person will ever commit a violent act during the rest of their life. Non-capital sentences, on the other hand, maybe the follow-up period should be whatever the length of the sentence, the maximum sentence would be, were the person to get the maximum sentence. Because obviously after the person has served their entire sentence, the law no longer has authority to continue to confine the person. So maybe that should be the follow-up period. And conceivably, it should be something that's even shorter because, and I'm not going to go into this in detail, but the Supreme Court has held that in fact, it may be illegitimate to hold a person after the minimum sentence at which time a parole board makes a decision about release, unless there is a parole board hearing. So in other words, the Supreme Court in Garner has held that a person is entitled to parole board decisions on a relatively routine basis. And if that's true, maybe the follow-up period should be the time period between the sentence and the first parole board hearing. And then the time period between the first parole board hearing and the second parole board hearing. Same thing with sexually violent predator commitments. Perhaps the follow-up period should be the time period between annual reviews. And in fact, in Kansas versus Hendricks, which you may know, is the main Supreme Court case dealing with sexually violent predators, the Supreme Court suggested that annual review be on an annual basis. So maybe that should be the follow-up period. Pretrial detention, the follow-up period is pretty clear, right? It's not a year or 2 years. Typically, the typical pretrial detention period, at least by statute, should normally be only 6 months, which means that should be the follow-up period, not 3 years, not 4 years, but 6 months to a year. So the follow-up period is going to differ depending upon the context. And finally, the fourth variable under the FIT principle is intervention. So what am I talking about here? Even if a person has relatively high, is associated with a group which has a relatively high probability of recidivating in a violent way over the relevant period of time, that does not mean that we have to put the person in prison. There should also be information about alternative dispositions. And there's legal basis for that requirement. Jackson versus Indiana, where the court held what you see here. The nature and duration of confinement should bear a reasonable relationship to its purpose. Well, if the purpose of a sentence or decision to deny parole or pretrial detention is prevention, is public safety, then what Jackson says is you've got to mold your intervention to do the best job possible protecting the public. It may be prison is the best way to protect the public, but not always. So for instance, there might be alternatives. And this is what risk management is all about, right? And this is what the HCR 20 directly addresses. Prison might be one way of addressing risk, but there are other ways of addressing risk as well. The VRAG is very poor at this, by the way. VRAG gives us virtually no information how to address risk. The HCR 20 LSI revised does give us some information about that. So that would be, and I think it would be useful information, I think is required information if the law is to do its job with respect to what should happen to an individual who's considered risky. It would be very nice to know the following pieces of information. Now I realize this is a lot to ask, but there is some research on all of this stuff. It's very possible that people who are managed in the community do better than people who are managed in prison. And I have here CFMST, multi-systemic therapy. You all may know about this. It's very intensive therapy that is done in the community. And apparently it's much better at reducing recidivism amongst violent juveniles, not just any juvenile, but violent juveniles than prison is. And it's much less costly to boot, which ought to be attractive to judges. So that kind of research would be very useful and should be presented to the legal decision maker. There's also all this kind of research that could be useful, either in a general way or in a specific way. Basically, the end result of all this research is prison does not do a good job of reducing recidivism. In many ways, it's criminogenic, and judges ought to know that. And it's very possible that even a high-risk individual would not be put in prison or would not have their sentence enhanced if the judges were aware of this stuff and a good alternative could be presented. And to the extent there's research on this, that would be particularly useful. Now, maybe some of you are thinking, well, but judges aren't just looking at risk when they're sentencing, and parole boards are not just looking at risk when they're deciding whether or not to release someone. That's true. Retributive considerations are also relevant. Culpability, blameworthiness is also relevant. That's fine. And maybe the judge decides, well, the person's low risk, but they did something pretty bad, so I'm going to give them the maximum sentence, 10 years. Okay, fine. But nonetheless, if a risk assessment is asked for, it still should be provided, and then the evaluator can provide information about, okay, assuming the person is going to prison, what's the best thing to do while they're in prison? And again, the HCR 20 LSI revised can be very useful there. Okay, so that's the fifth principle, and that's what I want to spend most of my time on. I do want to say a few words about the validity principle and the fairness principle. And then I'll be done and I'll see if there are any questions. I assume there will be because I'm going over this very quickly, but I've got an hour. Okay, so what am I talking about with respect to validity? This is a concept I think that's very familiar with all of you. All of you are probably familiar with the Daubert decision, which was later codified in Federal Rule 702, and most states have a similar rule, which require that if an expert's going to testify, the expert has to use reliable methods that are applied reliably. Okay, that's the idea. Now, one legal issue is whether Daubert applies to any of the contexts we're talking about. Because what are we talking about? We're talking about sentencing, pretrial detention, sexually violent predator commitment proceedings. A lot of courts say Daubert doesn't apply in those proceedings. So at least technically, basically, there's a lot less concern about validity in these proceedings. I think that's ridiculous. Daubert involved a tort suit. The Daubert case itself involved a tort suit. No deprivation of liberty involved at all. We're just talking money changing hands. If Daubert applies there in a tort suit, it clearly ought to apply. We're talking about sentencing, parole decision-making, SVP commitment, pretrial detention. And it's ridiculous, and this is my opinion, ridiculous to say otherwise. Daubert ought to apply across the board. But even if Daubert doesn't apply, I think any court would be unwilling to say, oh, we don't care at all about the validity of the information we're getting. I don't think any self-respecting judge would say that. There does have to be some attention paid to validity, even if Daubert does not apply. So what do I mean by validity? And you can read it for yourself. I'm not going to go into this in detail, but we'll say a few words about it. I think there are a lot of different kinds of validity that are to be considered. Calibration validity, discriminant validity, external, local validity, also reliability, which of course is not really a form of validity, but it's relevant here, current validity, and whatever is being done ought to be applied reliably, to use the language of 702. I'm going to talk a little bit more about 1 through 5. I want to make a point about all of them, though, before I talk about 1 through 5 in more detail. I don't think a judge or parole board has to make any decision about 1 through 5. Those are general issues that can be resolved by an independent entity, whether it's a university that studies the instrument, whether it's a government agency that studies the instrument. Calibration, discriminant validity, and all these other validities, 1 through 5, can be addressed through an independent entity. The only thing the individual judge or the individual parole board has to do is look at number 6. Assuming the instrument has been validated 1 through 5, all the judge has to do, or the parole board has to do, is make sure the evaluator is correct in terms of the risk factors this particular person has. So if the evaluator says, oh, this person has 3 convictions for violent felonies, and it turns out there's only 1 conviction for violent felony, the judge's job is to make sure that correction is made. And then the judges also, and the lawyers have to make sure that the weights are added up correctly. That's what I mean by applied reliably. Everything else can be evaluated by an independent entity. So the job of the judge and the parole board and the legal decision maker is not all that tough. It's just number 6, not 1 through 5. What about 1 through 5? Well, calibration validity you're all familiar with. And the way I think this plays out, this is that VRAG chart I showed you before. I think it would be very useful if developers could develop the PPV, the positive predictive value, for every cutoff point there is. The VRAG's got 9 cutoff points. Other instruments got 3 cutoff points, or 4 or 5. I think we need to know the category base rate for each of these bins. And you've got here the category base rates for each of the VRAG bins, right? 15%, 18%, 22%, and so on. That's what we need. Now, I know that this, what I'm calling the category base rate, is very dependent on base rates within the jurisdiction. I know that's a problem. It's an empirical problem. Hopefully, developers can deal with it in a way that allows you to provide this information with relatively sensible confidence intervals. I am running out of time. I'm just going to allude to this issue. You may be aware of this debate between Stephen Hart and Grant Harris and various other people as to whether or not we can say anything meaningful along the lines of what I've been talking about, that a person is in a group 30% of whom have recidivated, or is in a group 75% of who have recidivated. I think Stephen Hart would say you can't do that. It's just not possible. You can't say anything about an individual based on group data. Grant Harris argues to the contrary. I'm not going to wade into that debate. I don't think the courts are going to have a problem with risk assessment that relies on category-based rates. But I just want to flag the issue and leave it alone. If you want to ask me about it during question and answer, fine. I happen to think the courts will be fine with the way Grant Harris thinks these kinds of things should be discussed. So that's calibration validity. There's also discriminant validity, which is usually described in terms of AUC values, area under the curve, and I assume most of you know about this. I think discriminant validity is important also. I think calibration validity is the most important. In other words, these bins, this, from a legal perspective, this is the most important information. You may not think so from an empirical perspective, but from a legal perspective, this is the most important information. But the law should also know about discriminant validity, just to make sure the instruments can discriminate between high and low risk individuals. An individual came along and said, 100% of the people I'm evaluating are low risk. They'd probably be right 90 to 95% of the time, given the base rate for violence amongst any group. But the law doesn't want that information. They want the evaluator to be able to discriminate between high and low risk individuals. And that the AUC value can help us figure out whether the instrument's good at that. It can also help us figure out legally whether the opinion is relevant under the definition of relevance. So what should the AUC value be? I'm not going to go into this in detail, but I think you can make an argument. It should be somewhere around 0.7, 0.75, because that's the way the law defines clear and convincing evidence, which is often the legal phrase that's used in the risk assessment area, that the state has to show clear and convincing evidence the person's risky. Then there's external and current validity. You're all familiar with this. Even some courts recognize this is important, that tools have to be renormed on a routine basis, and they need to take into account that there are populations and subpopulations, which might include, for instance, the fact that you may need different instruments for males and females. You may even need different instruments for different ethnic groups. There is some research suggests maybe you need to do so, though other research suggests you don't. I think the strongest evidence with respect to this is male versus female. And that's something that needs to be investigated empirically. Interestingly, Virginia requires that those instruments I referred to earlier be renormed, revalidated on a routine basis. And so Virginia does that. And that's the kind of thing I think legislatures should require. So that's the validity point. And then finally, the fairness point, which I'm going to go over in 3 minutes or so. I'm sorry, one last reliability point. You know what reliability is all about. There should be inter-rater reliability. Unfortunately, there's very little research on this with respect to most of the instruments. There should clearly be training, and the judge or pro board should demand that the individual doing the evaluation has had some training in doing risk assessment using the relevant instrument, and so on. And then here's a controversial point, among many controversial points I'm making. I argue in the book, which is called, remember, Just Algorithms, that the algorithmic decision, if you're using an algorithm, if you're using a risk assessment instrument, that ought to be dispositive, unless there's good reason for departing from it. Why do I say that? First of all, there's a lot of research that shows when evaluators adjust the algorithm result, upwards or downwards, they tend to be more inaccurate. That is, relying on the algorithm, you tend to get a more accurate result than if you adjust. And also, the other reason is, if there is an adjustment made, it's usually in the upward direction. And again, since it's more likely to be wrong from a deprivation of liberty point of view, that's not a good thing. Here is some research that illustrates what I'm talking about. Kentucky used the PSA, which I referred to earlier, to make pretrial detention decisions. And you'll notice right after the introduction of the PSA, which is represented by the vertical line, release rates went up. That's illustrated by the blue line. Release rates is represented by the blue line. At the same time, crime rates, which is represented by the orange line, stayed the same. Well, that's exactly what we want to have happen. We want release rates to go up and crime rates to stay the same, or ideally go down. But then you'll notice over time, the release rates went back down again. Why did that happen? Judge decided they knew better than the algorithm. They were using the PSA here. They said, our opinions are better than PSA. We don't rely on this numerical mumbo jumbo. We're going to go with our seat of the pants assessment. Well, so they went back to the seat of pants assessment, and release rates went back down, which I think is unfortunate. The whole point is to do this, not this. So that's why I argue in Just Algorithms, we should just use algorithms unless there's good evidence to the contrary. Finally, we get to fairness. This is the last principle. And there are two issues I want to address here, and then I'm going to stop. The first issue is there may be a constitutional argument that certain kinds of risk factors simply can't be used. Race is an obvious example of this. And the Supreme Court itself has said you cannot use race as a risk factor. Okay, fine. What about gender? Well, gender is a protected class. You're not supposed to discriminate based on gender. Does that mean you cannot use maleness or femaleness as a risk factor? You notice that some of the instruments I described earlier do use that. The VRAD uses that. That's an issue that has yet to be litigated. Another risk factor that would be unconstitutional if used might be religion. And some people have argued even socioeconomic status cannot be used for constitutional reasons. If that is true, and again, this is yet to be litigated, that could wipe out some other kinds of risk factors that are commonly found in instruments. And especially if you say, and anything that correlates with socioeconomic status can't be used. Then you've wiped out a whole bunch of risk factors. So that's point number one. Point number two is, a lot of scholars have argued that any risk factor that's not based on criminally blameworthy conduct cannot be used. Why is that? Well, because these people argue we're talking about criminal justice. Criminal justice should be based on blameworthy conduct. Okay, so you can use the crime that the person's just been convicted of or just been arrested for, and you can use prior criminal history. That's blameworthy criminal conduct, but you can't use anything else. Well, those of you who have used these instruments know that's going to be a problem, right? Yes, criminal history is a major risk factor, but there are all sorts of risk factors that are not criminally blameworthy conduct. Diagnosis is not criminally blameworthy conduct. Even substance abuse is not criminally blameworthy conduct. Family life, clearly not criminally blameworthy conduct. And age and gender are not only not criminally blameworthy conduct, they're not conduct at all. So that creates a huge problem if that argument wins the day. A compromise is to say that if we're using a risk factor that is not based on criminally blameworthy conduct, like age and gender, it's got to be very useful risk factor. It's got to give us a lot of incremental validity. So the argument might be, hey, age and gender are very useful risk factors. So even though they're not criminally blameworthy conduct, we can use them. On the other hand, marital status, location, they're also not criminally blameworthy conduct. And maybe we shouldn't use them because they don't provide us with very much incremental validity. Marital status does not give us much incremental oomph in terms of figuring out who's risky and who isn't. Now, again, there's virtually no law on this. I'm just highlighting what could be an issue in the future. And then finally, the final thing I'm going to say is that fairness also means that, as I've already suggested, there needs to be independent verification of the calibration, discriminate, external, and current validity by a university, ideally, but a government agency otherwise. And that there should be some kind of adversarial process, ideally involving lawyers and judges, when a risk assessment is made. As some of you know, unfortunately, that's not always the case. In an SVP commitment hearing, there will be a judge and lawyers. Pretrial detention, in fact, there's no right to counsel. There may not be a lawyer there. Parole hearings, once again, no constitutional right to counsel, maybe not a lawyer. I think that's a huge mistake. I think if we're doing risk assessments, we need lawyers. Okay, I've gone through this very quickly. I'm going to stop here because I think I've spent exactly an hour talking about this. And I'll see if there are any questions.
Thank you so much, Chris. Yes, we do indeed have a lot of questions here, and you've given us a lot to think about in ways that impact the very work that.
Yeah, I tried to do a whole book, 180 pages in 1 hour. So there you go.
Impressive. The first question I was going to bring up here seems to tie into this last point about independent verification. Somebody's asking, based on your legal background and involvement with psych instruments, do you have any recommendations for future revisions for existing measures? Basically, where do we need the most help in this area?
Well, it depends on, I mean, again, it's up to the law to tell us that. I think, I have a whole chapter on this, that we ought to use risk assessment as sentencing. And some states are doing that, either at the front end when the judge decides what the sentence is going to be, or at the back end at a parole board hearing. And if risk assessment instruments are used at sentencing, I think, and I've already signaled what I think we ought to come up with category-based rates for whatever the cutoffs are. And I would hope there is more than 2 cutoffs. I would hope there are 3 or 4 or 5 cutoffs. I know it's hard to produce that information, but I would hope you'd get category-based rates for at least 3 cutoffs. And the outcome variable would be conviction for violent offense. And the duration would be, I don't know, something like 5 years. And there would be information about alternatives to prison. So I know that's a lot. That's a big ask. And by the way, I should have said this earlier. I think if you followed everything I'm prescribing, it would be almost impossible to come up with a good risk assessment instrument. I will admit that up front. A risk assessment instrument that comes up with good category-based rates, for which they're pretty narrow confidence intervals, and the outcome variables I'm suggesting, and the durational limits I'm suggesting, and the intervention information, be very hard, if not impossible. So this is all aspirational. So I guess the answer to the question is aim for all of that stuff. You're not going to be able to do it perfectly. No way. Risk is a very hard issue to deal with, and we all know that. But I think this is what we should be aiming for, as opposed to just say, go out there and tell us if you think the guy will do it again, which is basically what the law is telling us now, right? That's all the guidance it's giving you. I think that is, as I've said several times now, horrendous. So I guess I'd say we need most of our the empirical work to be done in the sentencing context. And maybe that's a different answer. That's more of what the question is aimed at. Sentencing is the most important area because more and more states are thinking about risk in the sentencing context. Not all states. Some states don't think about risk at all, but about half the states think about risk on a routine basis, and they rely on very poor information. And so I think risk developers could be very useful there. Pretrial detention, we've already got some fairly good risk assessment instruments. I think it'd be good to develop better instruments, but I think the Arnold Foundation instrument is not bad as risk assessment instruments go. And SVP, I won't get into that. There are some problems there along the lines of what I'm talking about.
Certainly. We have a question about, someone was wondering how these principles would balance the benefit of law being purposefully vague legal statutes tending to allow for societal and empirical or scientific progress.
Yeah, well, that's the problem. We're not getting the progress. Okay, if the law continues to be as vague as it is, developers don't have any incentive to do the kinds of things I'm talking about. Okay, because the court's never going to exclude the evidence based on the argument, oh, this doesn't fit what we want to know, this is not valid enough, the risk factors you're using are not appropriate. The law needs to specify what it wants, and then it needs to exclude opinions that are not based on what it wants. Now, I guess if I was going to rephrase the question, it would be, well, if they're very specific criteria, it may turn out we can't really answer them. Well, that would be useful to know, okay? And maybe then we change the criteria. Or maybe, and this is what I alluded to earlier, we'd stop using risk as a variable in legal decision-making. I happen to think we should use risk, but I think it's up for grabs whether risk should ever be a legitimate criterion in the criminal justice system. And by the way, there are a lot of scholars that think it should never be. The argument being we should never deprive a person of liberty based on what they will do in the future, period. It's totally illegitimate and even unconstitutional. If you think of the word punish, punish means to do something to a person based on what they've done. You don't punish someone for what they'll do in the future. So that's a perfectly legitimate argument. But unless we force the law to think about this, we're never going to address that issue head on. We're never going to get a jurisprudence of risk. So I think I would respond, I think we have to do what I'm talking about so we can get progress, both legally and empirically.
Seems like related to this is this question about how the law can keep up with technology, particularly defining crimes that perhaps years down the road, particular examples being technology-based sexual offenses that didn't even exist years ago. How does the law keep up with all of this and in order to assess
Yeah,
this?
I'm going to say two things, one of which is somewhat responsive to the questions and one of which is not responsive at all, but it reminds me of something I think is important. Again, the question, I think, asked a normative question. Okay, what should be the outcome variable? And it may be society will decide only physically violent crimes. So if we're talking online porn, that might not be an outcome variable that would be relevant to deciding whether a person's sentence should be increased because we think they might engage in online porn again. Or it might be a relevant outcome variable, but we'll manipulate the intervention criterion. We'll say, well, they shouldn't go to prison for that, but we should take away their computer or in some way prevent them from ever going online or set in some kind of blocking scheme. And there are lots of ways, of course, of addressing different kinds of crimes, which you all know better than I do, right? Prison is not the best answer to many, many situations, even violent situations. So that would be one response is the law has to roll with progress, with developments, with new crimes and decide what the outcome variable is going to be. The non-responsive point is this. I'm using the question about technology to talk about artificial intelligence. Right now, none of the risk assessment instruments with which I'm familiar use artificial intelligence in any serious way, right? In other words, I'm calling machine learning, deep learning. I think it's coming, but it really hasn't happened yet, right? That is the use of large databases to try to figure out who's risky and who isn't. That is probably going to come either from private companies or from the government. And I think unless that's made totally transparent in the way the VRAG's made transparent, I think it should be impermissible to use those instruments in a criminal case. Now, maybe in other settings, figuring out who's employable, figuring out who should get welfare, maybe there, but not in the criminal justice system. It should never be permissible to deprive someone of liberty based on a non-transparent, on an opaque instrument. That's why I have a problem with the compass. Remember, that was the second instrument I talked about. They're claiming trade secret law. We have no idea what the risk factors are. They might be relying on race. We don't know. We don't know what the weights that are accorded to variables are. We need to know that in the criminal justice system, or I think we should not allow use of the instrument. And artificial intelligence will raise that issue, I think, in a very real way.
I think we have time for one more question I'll throw your way. So a lot of your discussion was about identifying risk. Somebody had a question about some of the benefits of some of these tools like the HCR20 is the risk formulation piece, this idea of informing not just is a person going to get services, but what kind of services we might recommend here. What pointers do you suggest to deal with post-sentencing offender management?
Yeah, I think that's incredibly important. I spent some time in my book on that. I think the ideal evaluation for a judge or parole board would be a combination of something like the BRAG and something like the HCR20. Okay, you need to know this probability information, which the HCR20 does not give you, to figure out whether they're in the group that should have their sentence enhanced, for which there should be intervention, or there should be no intervention at all. But if there's going to be intervention, I think the HCR20 is absolutely crucial. VRAG's useless in that regard. The HCR20 can tell us, okay, what should the intervention consist of? If it's going to be diversion, but we still supervise the individual, what should that consist of? If it's going to be imprisonment, what should happen in prison? If it's going to be release on parole, what should be the parole conditions? HCR20 or the LSIR can be very useful in those situations. And the other reason they're useful is they consist largely of dynamic factors. So in other words, you're telling the offender, what does the VRAG tell the offender? You're hopeless. Your VRAG score is never going to change, right? These are all static factors that are never going to change. That's horrible. Okay, that is not fair. Going to this fairness thing we're looking at right here. Oh, I'm sorry, I didn't give you the last thing, which is directly relevant to what I'm saying. The law should require dynamic, changeable risk factors. Okay, it should require that, because otherwise the message you're sending to the offender is, you're always going to be high risk. And that's it. The HCR20, the SIR give a person hope. They tell the person what they can do to lower their risk profile. And I say CF, the First Step Act, many of you may know about the First Step Act. That's the federal law that Trump signed 3 or 4 years ago now. And there's lots of problems with the First Step Act, but one thing it does is it says to the person, even though you may be high risk now, if you complete the following 4 programs, you will automatically be only medium risk or maybe even low risk. And your chance of release will be much higher. Well, I think that's the right idea. I'm not sure the way the First Step Act carries it out is great, but the HCR20 could be instrumental in providing that kind of information and avoiding what the VRAG and the Static 99 do, which is basically give you a risk factor you can never change.
This reminds me of the
a
SVP
risk
laws.
profile you can never change. Yeah, sorry.
Certainly, it reminds me of the SVP laws that you were discussing, where some states specifically require a static measure as part of the assessment process.
So one thing I'll say about the Static 99, the developers of the Static 99 themselves have realized this problem, right? And now they have this additional thing you're supposed to do with the Static 99. That's sort of a personality assessment added to Static 99 that gives you some dynamic variables. And with that addition, it's better. I still don't think it's great, but it's a hell of a lot better than it was when it was all static.
Incorporation of the stable.
Yeah, the stable, right.
Yeah. Well, that's the time that we have. Thank you so much, Chris Slobogin. I really appreciate all this information that you've shared with us. I think it gets at a lot of just the core things that a lot of people in the audience practice and really think about what we're doing and what the purpose is and how it can actually meet the purpose of the law.
Yeah, and I think I think the book fleshes this out pretty well, but if you don't feel like spending money on a book, I also have an article that covers some of this in Wake Forest Law Review. So there are things to look at.
Wonderful. Thank you so much.
All right.
That is the wrap up for today's Law and Mental Health series. We will see you next week.
Okay. Thank you very much, everybody.
Absolutely. Take care.